contribute something to the protection of global public goods. I would like to invite Eleanor Fox to start with her presentation.
Thank you very much, Joseph. It is a pleasure to be here, and thank you for this wonderful conference. Is this on? Yes. Okay. Jerry has challenged us. In the very first sentence, in his very first remarks, he said, intellectual property has expanded beyond its bounds, and what will be there to contain it? Will antitrust be there? Will it be able to, and will it push back the borders of excessive intellectual property protection? Jerry, I am sorry to tell you, not very much. Sometimes not at all. And I want to tell you why, but I also want to tell you where there's some margin for movement and where there is some hope. Okay? So first of all, I want to talk about the two major antitrust jurisdictions, which is the United States and the European Union, and where they are today in their antitrust thinking and the antitrust thinking that borders on intellectual property. And then also, what about international antitrust? Might that be there to help out on the problems of distributive justice and less developed countries, even if the United States might be a little conservative these days? And finally, how can the less developed countries and the developing countries protect themselves from certain abuses of, for example, intellectual property restraints? Well, first, the story on U.S. antitrust, and probably a lot of you know this very well, and I'm not going into any detail, but as you undoubtedly know, there was a time, 1950s through mid-70s, when U.S. antitrust was very strong and very robust and protected against power and protected against abuses of power. And for a long period, in this period of time, antitrust had the upper hand over intellectual property and was very willing to push back the borders and at least police the borders of abuse. Well, in the 1980s, beginning in the early 1980s, we had a huge paradigm shift in antitrust. Whereas in earlier times, and really for most of the century, it had been just against power. It began to be for efficiency, and it began to take a very step-back view of when it is appropriate for the antitrust agencies to intervene in the marketplace. Beginning in the 1980s, our new paradigm was this: no antitrust intervention is appropriate unless the defendants were doing an activity, and cartels is your number one activity, an activity that is likely to lessen output and raise price. This is the efficiency paradigm. It means that, while cartel cases are still strong, always have been, through all the years, cartel cases fit that paradigm, not much else does. Monopoly cases are rare. It is very hard to prove that a practice by a monopoly firm is giving it more market power. And that's what normally has to be proved. Most of the intellectual property cases are the single firm actor cases, which would be in the monopoly slot. Of course, if they are covers for cartels, that's easy game if you could prove it. Beginning in the 1980s, we began to be consistent with this paradigm, especially worried about free riders, especially likely to believe that what a firm does is efficient, and one of the efficient things is to protect against free riders. We began to take on an understanding of actors' need for freedom to act, even the monopoly firms' freedom to act, on the idea that this really is good for all people, that if you give the firm freedom to act, that firm will almost surely be acting in the interests of consumers. we've had a number of Supreme Court cases over the last 10 years saying the following: antitrust law is not about fairness. And in addition, we have had a number of Federal Circuit Court cases on the intellectual property antitrust interface saying if somebody has intellectual property protection, that person has the absolute right to refuse to deal. The right to refuse to deal is of the essence of the intellectual property. As you know, we've also had the Microsoft case, and the Microsoft case is more nuanced than the Federal Circuit Court. In the Microsoft case, as you know, Microsoft was found liable as a monopolist, maintaining monopoly for a number of practices. Half the case was dismissed, half the case was upheld. In the part of the case that was upheld, a number of the practices involved acts that were involving intellectual property. For example, Microsoft said, I invented this operating system. I can do what I want to with it. If I don't want Netscape's icon for browser on the screen, I can tell Compaq and the other PC manufacturers to not put it on the screen. That was a claim that was rejected. And indeed, the Court of Appeals for the DC Circuit said, that's like saying if you own a bat, you have the right to hit people over the head with it. However, there are other aspects of that case that are very consistent with this non-interventionist mode. For example, one of the things Microsoft did was, as you all probably know better than I, that it took the Java language under a license in which some microsystems which licensed it was expecting it to use the language as some Microsoft system developed it and hoping to be able to use Java language as a cross-platform language so that it could operate on any platform, Microsoft's operating system being only one, but it hoped to be developing other alternatives to Microsoft's operating system on which Java language would operate, and Microsoft changed the Java language so that it tailored it for Microsoft's operating system and it would not be usable for anybody else's operating system. And the court said about that change, it wouldn't even scratch the surface, that was invention, hands off for antitrust. And that's very typical because some of us might call it product change, some of us might call it predatory product change. That's not the way it's thought about by the US courts. It is invention, and we take the very long arm approach. Now, the one other thing I want to tell you about U.S. antitrust law is embodied in a case that's up before the Supreme Court right now, and it's called Trinco against Bell Atlantic. It's an essential facility case. We do have a pretty narrow view of essential facilities, but I had thought we still had a doctrine. It's about an allegation that Bell Atlantic was denying equal access to facilities and to access to the loop and to the level of telephone service, retail service that Bell Atlantic was supplying to itself. And the Second Circuit denied defendants' motion to dismiss. The case is up on cert before the Supreme Court. The government has filed a brief in the case, asking for cert, and said in that brief, we really don't have an essential facilities doctrine. You just look under normal Section 2 law. It's nothing special. It's the normal Section 2 that Bell Atlantic had to be getting more market power by these acts, or else there is no case. And it also said further, European Union has an abuse of dominance law. We don't. U.S. doesn't. We have to watch this case. It's not only about essential facilities, it's relatedly about discrimination and leveraging. It is totally possible that our Supreme Court in this case will wipe out what is left of the doctrine, there's not too much left, of leveraging without getting more market power. And Also, that it might wipe out what some of us thought was a doctrine that if you own an essential facility, you must not discriminate against your competitors and you must not use leverage against your competitors. Now, the reason why this is really important for intellectual property is that a great number of the, let's call them restrictive business practices that one would think about in connection with intellectual property would be just such abuses of power in a context where the abuser does not necessarily get more market power, but is using market power. And our courts have generally, but not 100%, been saying that the mere use or mere getting special advantages from your market power is not an antitrust violation any longer in the United States. You must be also getting more market power. So we'll see what happens on Trinco. Now, quickly, we turn to European Union. European Union law is under the Treaty of Rome, of course. The Treaty of Rome law has Articles 81, 82. 82 is the abuse of dominance provision, and of course that says no one shall abuse dominance. And in that respect, it is different from US law. It definitely does find violations of Article 82 when you have a dominant firm that uses its power in its market of dominance to get advantages in another market. American antitrust agencies have been telling them that's the wrong way to analyze and that they don't have their economics right, and have been putting a lot of kind of subtle pressure. And we'll see how the EU law develops because there are some authorities now where EU law seems to be working in the shadow of US law. One other point about, or two, about EU law is whereas US does not have an abusing pricing law, EU does. In other words, under US law, to charge a monopolistic price if you're a monopolist is not a violation of law, no matter how high that price is. And our theory is it's the free market theory, and also the limits and competence of a judge theory, that we hope our market, that will be a signal for others to come into the market. We hope the market will work. We hope the market will push down the price. We don't trust the judge to say this price is too high. And we don't want price control by a judge. EU law and most other nations do have an abusive pricing law. It's seldom used. I think EU itself understands the claims against it and reserves for extreme cases. However, it is said in an intellectual property case early on, Serena, that one can have an abuse of dominance violation for charging too much for intellectual property. Then the other point on EU was there have been a couple of really interesting cases about, in effect, access to intellectual property as essential facility in the European Union. One, probably all of you know, McGill, in which access was granted under particular circumstances, and another pending adjudication right now, which is called IMS, and it's not clear whether EU will be walking in the shadow of US law or not. A couple of statements by the Court of Justice and Court of First Instance have mentioned the problem of, or have mentioned the proposition that people have to be free to use their intellectual property the way they want to. So the two dominant jurisdictions are very reluctant to push back the boundaries of intellectual property law, even excessive uses of intellectual property. US much more reluctant than EU. Now I said I would look at, is there some margin for movement? I want to come to one really strong ray of light, and that is even on the US side. Our Federal Trade Commission, under the chairmanship of Timothy Muris, has been taking very aggressive actions to try to cut back the state action exemption and the related exemption of lobbying to get state action. And most of these cases involve intellectual property. How can we understand this in view of what I've said about the conservatism of US law? Well, actually, it's easy, because the, can we call it Chicago School theory, says, you know, let private firms do what they want. They're going to help the public welfare, just leave them alone, but keep the government out. The government, when it gets in there, it's going to mess everything up. The government action defenses are the government. And indeed, intellectual property is an exclusive privilege granted by the government. And so he does not want to see the expansiveness of the government-protected intellectual property monopolies. He's not saying they're illegal. He's trying to cut back on immunities. And I'll bring that in my last few minutes as to what we might expect on world antitrust scene. I just want to mention two cases that he's been looking at in case you do have an interest in this. BioVeil, this is misuse of the freedom to file in the Orange Book, and by filing a patent in the Orange Book, you can delay the putting on the market of generics that would, if used, infringe that patent. Well, some companies have been fraudulently putting listings in the Orange Book to get the automatic delay. And another case, which is Rambus, a company was working with the trade association to develop standards and fraudulently failed to disclose that the standard that it was urging and going on the track to get was a standard that relied solely on its technology, and everybody would need a patent from it. So those are the kinds of cases that we, United States Federal Trade Commission, are pushing to cut back the scope of exemptions. Now, last point, what about the hope for international law? I have to say just a word or two about what's happening on the international scene. You may know, if you're thinking about WTO, you may know that the United States was very, very strongly against an initiative in the WTO that would be a competition initiative on the theory that we can do everything we want to do ourselves, and we really don't have to go to a bargaining table and dilute our beautiful pure law, and that there would be, uncontrollable bureaucracy if we do sit down at a table, bargain for antitrust rules, and then have these faceless panels deciding our cases. I mean, this is the rhetoric, not mine. And for a long time, the United States was flatly opposed. The EU was proposing an international competence in view of the fact that activity is international. We only have national law. There's really a need for coherence at the very least. At the very beginning, EU was proposing for number one for its substantive rule, an abuse of dominance rule. Time passed. The Americans sort of chipped away, caused the European Union to try to find where is common ground. So the abuse of dominance proposition is not on the tables anymore. But Americans do not like cartels. Europeans don't want cartels either. The common ground for a substantive rule is an anti-cartel rule. And right now, as a result of run up to Doha and Doha, there is the proposition that we should have an anti-cartel rule for the world. It would probably, undoubtedly, in initial stages, have a lot of ability of nations to decide what exemptions they have, as long as there's transparency and disclosure of the exemptions. And the Doha agenda would include also due process and transparency and non-discrimination generally. We're not sure what's going to happen in Doha. That's a relatively narrow agenda, and yet it might not have much traction. And my thought as I contemplate the activities of our Federal Trade Commission today is, if there is a next rule, maybe we get an international anti-cartel rule. If there is a next rule, it might be the Murus rule. It might be that countries agree to limit the scope of state-protected exclusive privileges. It has to be worked out, but it's a good principle that would get very wide support. What about less developed countries? What does all this do? Even if we proceed to get it, what would it do for less developed countries? Would it do anything at all? In fact, in my view, for the most part, there are a number of developing and less developed countries that would profit from those principles: an anti-cartel rule, a restraint against excessive government-granted privileges, transparency and due process, plus didn't say this about Doha, but it's also in Doha, a multilateralization, thank you, a multilateralization of the bilaterals for helping one another in discovery. But is that enough? In fact, what would the less developed and developing countries want and do and try to get if they could develop the agenda themselves? The fact is that they'd probably want, number one, that abusive dominance principle, to protect, for example, if it's intellectual property, to protect against the leveraging and excesses of intellectual property. Well, they're not going to get it from the WTO. The U.S. philosophy is so much against that right now, and those with power set the agenda, you know, a right of veto. So I agree with those who have proposed that the less developed and developing countries must have a community of interest among themselves. They must, as John Barton said, get together and decide what would their agenda look like. I don't really have the hope that they'll get the agenda into a world agenda, but knowing what their best agenda is and always putting it on the table as a counter agenda that they are going to adopt and implement to the extent they can. It's pretty hard for them to implement, but putting it on the table as a counter agenda with a philosophy behind it is the least that should happen. So I agree with the model mongering of Peter Dreyhus, and just want to observe as I close, I agree with those who had said, you know, it's the countries that have the power that are going to set an agenda for the world if there is one agenda. And as Thucydides said in the Peloponnesian Wars, there is no natural justice. The strong do what they will, and the weak do what they must. But the weak may have an agenda that is going to highlight what is good for the weak.
Janis.
Well, thank you, Jerry, for the for the invitation. Now I'm going to see if I can give some suggestions to the weak, and maybe they can borrow something from the strong. We'll see. That may all get mixed up somehow or another. Jerry asked me to address this question: what lessons might developing countries take from U.S. patent antitrust law in formulating their own patent-oriented competition policies? And for me, that organized itself into three subsidiary questions, the first of which was which developing country might we be talking about here? And so I'm very sensitive to the problem of treating developing countries as a monolith here, and I don't expect that the problems and the conditions in India are the same as the problems and conditions in respect to patent-oriented competition law in sub-Saharan Africa and Latin America and so forth. But I'm going to treat them as a monolith anyway, at least for purposes of discussion, and suggest to you that the developing country that I'm talking about is one that maybe is better characterized as a least developing country, is one that has little or no legal tradition in intellectual property or in competition policy, and has little or no institutional infrastructure to support either one of those. And I'll work based on that assumption and hope that that model fits some, and certainly not all, of the developing countries that we might be interested in. Second question then was, what sort of room does TRIPS allow for developing countries to formulate patent-oriented competition policy in the first instance? And I suspect that was probably talked about a little bit yesterday morning before I got here, and certainly Professor Ullrich will talk a little bit more about that as well. So I'll mention that briefly in my remarks, and then go on to the third question, which would be, even if TRIPS does allow developing countries freedom to formulate these rules, which indeed it probably does, and to absorb lessons from U.S. patent antitrust law, are there any? Are there any for them to absorb? If not, this was going to be a very short talk. And my answer there, as you saw from the paper, is a mixed answer. I think that there is a bit that the weak can grab from the strong, perhaps, although not a whole lot. So this is kind of a short talk, but not that short of a talk. So let me talk then very briefly about the second of these questions, what room does TRIPS allow, and then move on to some proposals for what developing countries might borrow, what kind of learning that I think they might borrow from U.S. patent antitrust law. TRIPS Article 8 sub 2 and TRIPS Article 40 sub 2 are the most relevant to this topic. Article 8 sub 2 talks about appropriate measures that may be needed to prevent the abuse of IP rights. Of course, it also says these measures should be consistent with the TRIPS agreement. Article 40 sub 2 says that nothing in the agreement prevents member states from legislating in particular cases licensing restraints that might be abusive, and gives a short exemplary list. These provisions are very different from most of the provisions in the rest of the TRIPS. They're not coercive. They do give a great deal of room for developing countries or any other member countries to formulate competition rules. And so that means that this domain is a little bit different than the domain that the developing countries usually find themselves in these matters. They're not being coerced to adopt minimum standards here. They could adopt, as a matter of prudence, a wide range of standards, very aggressive, very minimal, non-existent, all across the spectrum. And the question then is, what should they do with this freedom that the TRIPS agreement has provided them with? And so here's my answer to, or my partial answer to the third question then, what should they do with this freedom? And it's a very broad proposal that needs to be fleshed out a lot more, of course. But the proposal is this. What they should do is they should adopt minimal standards, and I'm being a little cute there, I realize, but minimal standards of patent-oriented competition law. And what do I mean by that? What I mean by that is, at least as a first stage effort, they should voluntarily adopt patent-oriented competition standards that don't push all the way out to the edges of the allowable room that's allowed by TRIPS. Instead, they should take a more conservative, a more cautious approach. If this were a military briefing, we'd be talking about some kind of a rolling start, I suppose. And I really don't mean that they need to stop there. So that's why I say that this is a first stage effort, but I think that that is a good approach to start with. Now, why do I say this? I'll give a couple of brief reasons, and then I'll spend a little more time fleshing out what I mean by minimal standards. Why do I say this? Frankly, in part, intuition, that would actually work as a first stage strategy. Secondly, resource constraints. I'm assuming that developing countries don't have a lot of resources to spend developing this, and they don't have a lot of immediately available expertise. In addition to that, I think there are strategic reasons as well. I do take seriously the prospect, the risk, that aggressive competition policy could destabilize foreign investment flows. Jerry Reichman and others have written about that. And so that informs this approach. That's why this approach is conservative and cautious. And then, in addition to that, and this picks up a little bit on what Professor Fox was talking about, I do think this proposal also takes seriously the risk that aggressive national competition policy would stimulate a WTO or other international effort to create competition standards. And my guess is that the outcome of such an effort might not be satisfactory to developing countries at all. They might be better off not avoiding that scenario. So those are some of the considerations that lead me to think that, again, it is largely intuitive, but lead me to think that a cautious approach is warranted here. So let me flesh that out a little bit by talking about two areas here: institutional considerations and substantive considerations. Institutional considerations first. What have we learned in the U.S. about institutions needed to support a patent antitrust law? A couple comments here. First of all, we've certainly learned that a patent antitrust law requires or tends to aggregate anyway a complicated institutional infrastructure. We have that. We have a complicated administrative infrastructure that is involved in both policy and enforcement. We have a judiciary that you could say is sophisticated. It handles a lot of complex commercial matters. A sophisticated specialized bar, including some evil patent lawyers in the bar, also some evil antitrust lawyers, but a specialized bar, and let us not forget a robust academic enterprise as well. All these components of the patent antitrust institution in the United States. These things don't just occur overnight. It took them a long time to develop in the United States, and one observation there is perhaps then developing countries might wish to look very carefully at the formative period of U.S. patent antitrust law, so early 20th century U.S. patent antitrust law, to see what sorts of things they could learn about the development of these institutions. It seems to me that would be an interesting study to do, interesting paper to work on. A second observation about U.S. institutions is that U.S.-style patent antitrust law places a high stress on case-by-case development. And in the U.S., I think that high stress is mostly in the judiciary. It wouldn't have to be that way. It could be administrative case-by-case determinations. But either way, it places a high stress on having a sophisticated either judiciary or administrative tribunal. And I think the infusion of economic thinking into patent antitrust law is likely to keep it that way, at least in the U.S. Here one comment, the U.S. experience with the Federal Circuit, I think, is instructive. John Barton talked yesterday about a global Federal Circuit. I'm kind of interested, not in a global Federal Circuit, but I'm kind of interested in the idea of a specialized tribunal that has responsibility for both intellectual property and competition matters. Perhaps that's a long-term sort of institution that a developing country could look to and perhaps learn something from U.S. experience there. And last comment here relating to what might be learned about the institutions is that some of these problems, to me, seem at the very least overwhelming and maybe insurmountable for my hypothetical developing country in any event. And it leads me to think that maybe regional institutions and maybe having some responsibility for setting harmonized standards for both, not only IP, but also for patent-oriented competition might be at least necessary, and perhaps they would be desirable. So that just seems inevitable to me. So those are a few comments on the institutions. Let me turn to the last question, which is what might developing countries learn from the U.S. experience in substantive patent antitrust law? And so that's really the heart of it. If I want to talk about having developing countries adopt minimal standards, what would those minimal standards exactly be? My thinking about U.S. patent antitrust, and I don't think that this is by any means unique, would lead me to divide up into three areas. One, regulation of anti-competitive licensing practices. Two, regulation of unilateral anti-competitive conduct, monopolization, so forth. And three, regulation of patent misuse, understanding that that's an internal mechanism, a mechanism that's internal to patent law, and there are some others, as we talked about yesterday and again this morning, compulsory licensing, exhaustion rule, and so forth. So let me talk a little bit in each of those three areas and give you a rough idea of where I would direct a developing country to look in perhaps formulating some of these patent-oriented competition law standards. First of all, anti-competitive licensing practices. Jerry Reichman has written, developing countries need to develop a jurisprudence of licensing, and that is very central to my thesis here, too. Of course, we got to tell them what that would contain, but which is the hard part. But that's where they should start, in my view, is to develop minimal standards on licensing restraints, and that is what current U.S. law would teach us, as Professor Fox outlined a minute ago. Here, the FTC DOJ licensing guidelines came out in '95. It's a very interesting and helpful document. You don't have to buy into all of it if you're a developing country, but I think it's a very useful document. There are principles in there that I would suggest that they buy into. Don't presume market power from the existence of an intellectual property right. Create antitrust safety zones based on market power. And I would even go further to say adopt the general approach which applies rule of reason analysis to most types of licensing restraints. So that wouldn't apply to licenses that really are hardcore. Again, as Professor Fox mentioned, price fixing, market division, licensing restraints that really facilitate a price fixing or market division. Those are hardcore restraints that it could conceivably be subjected to a per se rule. But this approach leads one away from the extensive laundry list of per se rules and toward a flexible, admittedly more complicated, but more flexible rule of reason approach for most licensing restraints. Paradoxically, one little observation here, paradoxically, it may be that Article 40 sub 2 actually sends the correct signal here, or sends the signal that's consistent with what I'm proposing, insofar as it seems to suggest a rule of a reason approach, or a case-by-case approach anyway, and it gives a small exemplary list. One could expand. It gives a small exemplary list of restraints. I doubt that it was ever designed that way, but in an odd way, I think it might actually give the right signal for a starting point for developing countries. And I recognize, too, in making this proposal, this is not a very beautiful proposal, not one that's really designed for academics to love. Because what I'm really suggesting here, and I go into it a little bit more in the paper, is that developing countries really cherry pick from these resources without first developing a coherent, a uniform vision of what all this is supposed to be about. That they cherry pick, that they try to gain some experience in this area and gradually build up a coherent view. So it's not very beautiful, but what my hope is that it actually might work. And that seems to me as a very different approach, for example, than the approach that was taken in the negotiations over the transfer of technology regulation, where it seemed to me like there was an effort to come to a coherent worldview and press that worldview. And I could see efforts like this getting mired down, just like those efforts got mired down. So that also informs my approach here. So those are some comments on licensing restraints. I'll move just briefly in the last couple of minutes I have to the other two areas. First, what would I mean by minimal standards on unilateral anti-competitive conduct, or particularly what could developing countries learn from the U.S. experience here? Here I'm more ambivalent. Most current unilateral anti-competitive conduct cases at the patent antitrust interface are cases about anti-competitive enforcement, Walker process claims, handguard claims, so forth. And developing countries could look at this jurisprudence, and I think there are a couple of key points to take away. I don't think that they end up being terribly illuminating. One thing to take away is that the emphasis or the rise of this jurisprudence came relatively late in U.S. patent antitrust law. If you look at sources from before the 1950s, they're all about licensing restraints. They're not about unilateral conduct, and so that's another paper that I wonder about. Is this an historical accident, or is this really the way patent antitrust law invariably evolves? I don't know, but it's just something that I'd like to think about. Another comment, I think it's difficult to tell whether U.S.-style anti-competitive enforcement doctrine it really has a strong deterrent effect or not. And it would be hard to study that, because you'd have to ask questions about people who decided not to bring lawsuits for fear of antitrust liability here. It seems to me like that's not well understood, and maybe is not going to be very well understood. And then finally, one thing that developing countries should appreciate, I think, is that the importance of anti-competitive enforcement doctrine in the U.S. Might be peculiar to the U.S. approach to civil litigation. U.S.-style discovery, U.S.-style treatment of attorneys' fees, might make the threat of anti-competitive enforcement more real than it would be in other types of civil litigation systems. So I think that that should be at least factored in. And all those considerations make me just a little more ambivalent about how much is to be learned from that area of U.S. law. Finally, just a very brief comment on the doctrine of patent misuse and internal competition-oriented patent law doctrine. Here it seems to me I'm very less confident that developing countries would have much to learn from this jurisprudence. They should certainly look at it, and they should certainly think about the concept of a patent misuse doctrine that would go beyond the parameters of traditional antitrust doctrine. But, you know, the U.S. law has really become bogged down in that debate, it seems to me. And it's not clear to me that part of it, because so much of the U.S. debate involves whether misuse is really different from antitrust or not. And that seems like a sideshow to me for developing countries. That debate, and especially it's carried on today, might have more to do with jurisdictional allocation. Are these cases really going to be federal circuit cases, or are they really going to be decided elsewhere, than other higher level conceptual matters? So I would turn the focus away, thank you, from patent misuse doctrine. That's my intuition would lead me in that direction. So what do I conclude from all this? Well, this isn't meant to be a pessimistic assessment of the role of competition law in IP, but it's a very cautious one. It's a very careful one, and it is one that contemplates a rolling start. Suggests that developing countries could learn a bit from U.S. patent antitrust, but maybe not a lot. And there are many things that one could do to follow up on these very raw sort of proposals that I made. One of which certainly would be to do a lot of case studies of developing countries as they become TRIPS compliant to see what they do in terms of competition law. And so that would be something that I'd be very interested in seeing in the future in this area. And so that's all I have. Thank you very much.
Ladies and gentlemen, I really enjoy this conference. Everything is perfect and very stimulating and just great. And I'm all the more regretful that I cannot satisfy the interest of the conference, which would be, as Eleanor Fox put it, to bring antitrust at the help of the commons and to limit intellectual property. The actual developments are just going in the opposite direction. If you put it really, and the talk by Mr. Janis brought me on this point, if you really put it bluntly, then the entire problem would be that developing countries did not need the high-level intellectual property protection which we gave them, but they would need high-level antitrust policy, which we do not give them. And the whole point of my paper will be that, in fact, the development of antitrust law is going just precisely in the opposite direction of what might be desirable. And the fact that two rather liberal antitrust lawyers like Eleanor Fox and me do have the same approach and the same feeling actually means that the development goes in a direction which is not very favorable to what the thesis of this entire conference is. I'm trying to make 3 points in my 20 minutes. First, I want to introduce some neuralgic points in the TRIPS agreement's competition rules. Second, it seems to me that the TRIPS agreement addresses only yesterday's problems of IPR-related competition problems. Third, at present, we adhere to a competition policy in the field of intellectual property which holds no good promise for tomorrow's efforts of harmonizing competition rules as they relate to IPR. Competition policy has become instrumental and result-oriented it has become a policy instrument rather than a policy in its own right. It tends to serve economic interests rather than to contain them, and this, of course, is not the most promising approach. Now let us turn to the TRIPS agreement, the neuralgic points. The rules are relatively simple. The competition rules have been introduced in the TRIPS agreements as a last-minute endeavor, and they are a concession made to developing countries. They are not full-fledged. They rest on three principles. The guiding principles are, first, competition policy is a matter left to sovereign judgment by the members of the TRIPS agreement. Second, the requirement of consistency of such national IPR related competition policy with the TRIPS requirement must be satisfied. And third, the primary concern of the TRIPS agreement is with dissemination of protected technologies. The first point is clear, and Mr. Janis already mentioned this. It is entirely left to the members of the TRIPS agreement how to define their competition policy. Contrary to what even some of the developing countries seem to think, I'm thinking of the, alluding to the speech given yesterday by Carlos Correa, there is no limit on developing per se rules in the TRIPS agreement. You are not bound to have it as a rule of reason thing. The very simple reason for this is, and you said it, Eleanor, some years ago, and I tried to make the point clear, at the time of the TRIPS agreement's negotiations, the United States and the European Union did have per se rules. And it's unimaginable that we tried to abandon that during those negotiations. Very simple argument. The real problem of the TRIPS agreement is another point. Namely, if you look at the agreement, you have Article 8, the basic principles, Article 40, the licensing agreements. We are clear that Article 8 leaves the matter to national discretion. Article 40 is phrased a little bit different. There is an agreement that there are restrictive practices which actually do harm competition. And the conclusion might be, if that is a common agreement between member states, then it's inconceivable that they are free not to have any competition policy. So there might be an argument to say, yes, there must be a sort of minimum harmonization that at least the worst practices must be condemned by all the members of the TRIPS agreement. Now, if you look a little bit, this is a thesis which I once forwarded, and I have to revise my position a little bit, because if you look into the TRIPS agreement as one where the competition rules are a concession, a reservation made by member states, then it's difficult to imply from that reservation that it contains an obligation. However, to the extent that the non-enforcement of competition rules against IPR practices which are undercutting an adequate protection of intellectual property protection, abstention from antitrust enforcement may amount to an impairment of the duties under the agreement. And under this thesis, you may, for instance, challenge no challenge clauses, challenge exclusive grant-back clauses, challenge coercive package dealings, precisely those practices which are listed in Article 40, paragraph 2. And there are other conceivable items of the same nature. Okay. The next point is the consistency requirement. The consistency requirement does not mean that the members of the TRIPS agreement have to adhere to some sort of an inherency doctrine or reasonable reward doctrine or something. It is an outer limit of what you may do under the TRIPS agreement in terms of competition policy. It certainly means that you may not, by competition policy, undercut the protection. To give you an example, the European Union, in its first drafts on a block exemption for patent license, know-how license agreements, had a rule whereby the grantor of the license was disallowed to impose a duty of confidentiality on the licensee after the expiration of the license. That, of course, was beyond TRIPS, because you are really undercutting the trade secrecy clauses of the agreement. Yeah? So this you would have to preserve, and you couldn't go with antitrust laws beyond these kinds of limits. But otherwise, you have relatively little. Look at that. The consistency requirement means consistency with national intellectual property. This means, first, the consistency requirement relates only to protection granted on the domestic territory. It does not oblige you to abstain from antitrust enforcement solely on the ground that your enforcement may have extraterritorial effects on the intellectual property in other nations. Yeah? So if you, for instance, impose a duty to license, then this may have adverse effects on the value of intellectual property abroad. But this is not a matter of the consistency requirement. This is a matter of general public international law as to how far you can go with your extraterritorial enforcement of antitrust law. Second, consistency means related to the TRIPS standards. So if members do introduce intellectual property which is stronger than TRIPS standards, then they are at liberty to equally introduce antitrust laws which are stricter than they usually may be under the TRIPS agreement. Yeah? So it's probably the only area where you have some leeway of controlling the entire thing. The third point I want to make is, if you look at the TRIPS agreement, you have a split between promotion of innovation and promotion of dissemination. The starting point to see this, of course, is when we have intellectual property, we normally have two kinds of a dilemma. One is what I call the vertical dilemma, which we have discussed here. Intellectual property may prevent the follow-on inventor from using primary inventions. Yeah? This is the vertical, the research tool problem, all these kinds of things. And we normally regulate this by having first the disclosure requirements, second by having the fair use exceptions, and third by having licenses. And then we have the horizontal dilemma, which is that the optimal exploitation of an intellectual property protected subject matter is by competition, and that the exclusivity prevents this kind of competition. Again, the rule to overcome this is licensing. And it's only this latter licensing problem which the TRIPS agreement really tackles. If you look into Article 40 and the way it has been framed in Article 41, you see licensing is one variation of transfer of technology. It's not concerned with much more than this. And this, in my opinion, is the uneven split between promotion of innovation and promotion of dissemination in the TRIPS agreement, because we have these small rules on dissemination and broad rules on innovation. Yeah? This becomes very clear when you look at Article 8, the basic rule. Article 8 would be the only rule which enables you to control unilateral exercise of intellectual property. But in that Article 8 you have virtually nothing. And we all know that the real importance of intellectual property has changed not because people are applying for more patents, but it has changed because we have different subject matter nowadays, software, biotech, which is exploited in a different form, no longer in an embodied form, but in its intangible form. And this fundamentally changes the importance not only of the way of exploitation, but of the way you are legally securing this exploitation, namely by contract. And this brings you to the problem of what kinds of contracts and restrictive contracts are allowed, and when do we have refusals of deal which are, so to speak, pro-competitive or anti-competitive. And the whole problem which you have here, this is what Mr. Janis talked about unilateral refusals to deal, this entire area is not covered by the TRIPS agreement, however important it may be. And then you have a second problem. The second problem is the extension of protection to ever new subject matter. And the resulting problems of having sequential innovations with interdependent property titles and all these kind of things. How are we approaching this? We are approaching this as antitrust lawyers by all of a sudden rediscovering the virtues of patent pools and cross-licensing. Now, I have two remarks to make. One is an economic remark. I'm absolutely not sure that patent pools are really a sign of, so to speak, efficiency and innovation. They may rather be the result of a scarcity of opportunities of innovation and of a tendency of industry to follow a mainstream of technology. All concentrate on that area. Then, of course, they have to exchange licenses because nobody has sufficient creativity to look for another way of doing the same kind of stuff. And the legal argument is we used to look at cross-licensing and patent pools under two aspects. One was power and the other was collusion. Now we look at the patent pools as an instrument of lowering transaction costs. But if you look at this in an innovation perspective, you should see that the entire focus of the incentives granted by intellectual property has shifted from the exclusivity for the individual patent owner to adherence to a group, the patent pool or the licensing exchange arrangement between several competitors. The stimulants in competition has gone away from individualistic competition to coordinated competition. And you may have the same phenomenon in the, if you look at the, as how we deal with innovation nowadays. We are fostering collective or joint research and development. These arrangements for cooperative research and development are first a source for increased interest in intellectual property, because you need intellectual property to first join, to stay within, and then to get out of the cooperation. The only way that you can control what you brought into it, what you have in the cooperation, how do you get it out of the cooperation? Yeah? Second, of course, the collective effort is a good productive base for having ever more intellectual protection. And third is, we are, as competition lawyers nowadays, allowing people to have a cooperation group short of market power. And again, the emphasis shifts from individualistic competition to group competition. And the incentive granted by the intellectual property system becomes a function of the latitude of joining into all kinds of cooperative ventures. We have to see this. Now, the really nasty point in the entire thing is that the very doctrines, the anti-trust doctrines underlying these cooperative efforts, namely creation of synergistic effects, fostering efficiency, have now been transposed on the, in the field of bilateral licensing. And I'm taking some time in my paper on trying to show you that the EU approach to licensing has changed from a relatively liberal and fair approach, fair competition approach, to a mere efficiency approach. following the American example in the guidelines by the US Department of Justice and by the Federal Trade Commission, where you have a clear distinction between what they call vertical agreements, licensing agreements, and horizontal licensing agreements. And they achieve this clear distinction by assuming that normally a licensee is not a potential competitor of the licensor, even though everybody knows that by granting the license, the licensee obtains the potential of becoming a potential competitor to the licensor. Okay, the point I'm trying to make here is, when you look at the American and the European approach now, then the aim of the competition analysis is to bolster the licensor's incentive to innovate. The tools are my distinctions, vertical, horizontal, and a very broad definition of the efficient gains to be expected from restrictive licensing. The perspective is that of competition as a dynamic process and of market power being necessary to give a sound basis for the innovation. Yeah? And all this means that in addition to intellectual property, you get an allowance for restrictive practices as a basis for innovation. This is what I call innovation-oriented antitrust policy. And since I have only 2 minutes left, I must take a shortcut. And the shortcut is, if you base your competition policy on an innovation approach, then what you are really doing is you are shifting or you are altering the balance which we have had in the TRIPS agreement between, on the one hand, intellectual property as the incentive for innovation, and on the other hand, competition policy as a reservation in favor of members who would like to limit the excessive use of intellectual property. The new competition policy approach goes in the same direction as the intellectual property protection, and rather supports it. And this means that in the end effect, we will have a move towards innovation-oriented competition policy, because a dissemination-oriented competition policy inherently is the weaker approach politically and systematically. It's not by coincidence that the EU follows the American approach, because if one country broadens the basis for its innovation efforts, then the other countries are obliged to do the same. And if you put the entire thing in the TRIPS framework, then if you would have an effort of harmonization within TRIPS, you would end up with all countries having the same kind of innovation-oriented competition policy, for the very reason for which we have established the entire TRIPS system altogether. Thank you.
Thank you very much for the invitation. Well, I wanted to express my invitation, especially to Cherry, who has just left this room. Especially, I'm very pleased that some Americans still put some trust in old Europeans to contribute something, to the building of a new world. And I think that's really the outlook of this conference, to ask us and to give us incentives, inventiveness even, to develop new ideas in order to build such a world. Well, I have to admit that Jerry caused me quite a couple of problems, simply because he said to me, don't worry about those main speakers. You won't receive their papers before you have to prepare your comments. So just give us your conclusions. And then all I could do was to look at the main topic of this session. And the issue or the question, as Eleanor Fox put it before, how can competition law help us preserving public goods has to cause problems to competition lawyers, simply because as public goods are defined by non-rivalry, it can't work in a competition field because competition is about rivalry. Rivalry and non-rivalry does not fit together. That was my initial problem. And when you look at the economic literature, it tells you that in the field of public goods, you have to face a market failure. And the best way to solve the problem of this market failure maybe is to organize provision of this public good by states. And state provision is the contrary of market provision. And competition law protects markets. So somehow that was quite a dilemma to me. And I think I had to do what the rest of the group did. I went back to traditional competition policy and looked at the interface of competition policy and intellectual property law, which isn't quite the concern of this conference, because it's basically about those other concerns of access to intellectual or subject matter protected by intellectual property rights, which is quite a different concern. Nevertheless, I think this interface is really very important, and it brings me back to the economics of intellectual property. We all know that there is this incentive story, and we also apply the theory of property rights, meaning that we would like to have intellectual property rights in order to internalize positive externalities, but only to the extent that the social good derived from this internalization, namely inventiveness and creativity, that does not outweigh the social cost of excluding consumers. And I think the expansionist development we have to face nowadays in the field of intellectual property is a problem of excluding too many consumers. And that's the issue of this conference. So my first question would be, how can we solve this problem? And I think maybe that there are certain issues of applying competition law, but maybe competition law analysis as such can be very helpful. I think Hanns Ullrich did it to a considerable extent. So first of all, I think we have to analyze IP laws from a competition law perspective. In some instances, it seems that competition laws cause dominant positions as such. For example, in the field of design protection, when we protect spare parts, it seems that the result will be a dominant position. This is not a design of intellectual property law which contributes to competition. And it can't be in, I think it excludes, in this sense, it excludes too many consumers, and it imposes a too high price on consumers. And I think we should work in this field, and I totally go along with Hanns Ullrich's approach. What we have to try is to establish and to develop new, let's say, theories on how to draft intellectual property law in the sense that they contribute to a competitive market. Because also right holders are supposed to take part in a market, in a competitive market, and they should only recover their costs for inventiveness, but they shouldn't receive more. Now I come to the issue of international protection. I think maybe the WTO members committed a particular trade fallacy, simply because trade lawyers quite often suppose that there is a global market. And that's not the case. Since TRIPS, we definitely have international protection of subject matter protected by IPRs. These subject matters are ubiquitous, no doubt about it, but markets are not global. For example, just take the example of a small or a poor developing country, which is an importer of agricultural products. To impose IPR protection on seeds, for example, and even exclude a farmer's privilege doesn't contribute anything to the inventive structure of IPR protection abroad in the developed world. For example, at least for products which are used on a worldwide basis, simply because the market there is very local. You can't recover a lot of profit from this particular market. So invention or investment in invention is done because of the profits you will have in the developed world. And a farmer in this particular country won't be able to export. So there is no competition taking place somewhere else. So what is happening here is simply that without any economic justification for having an intellectual property rights, payments will take place from the developed world, developing country to the developed world. To this particular situation, we have also looked at the issue of international exhaustion. We know that, it was mentioned yesterday, that the principle of national exhaustion maintains local markets. So I would support speakers yesterday who mentioned that having a principle of national exhaustion also helps developing countries, because this principle keeps markets local. And so there is no competition in the developed world, but that's also a justification for allowing exceptions to intellectual property protection in developing countries, because there is no competition and there is no considerable loss if there is no protection in those countries. Last point, in the field of medicine, I'm not an expert in this field, but it seems to me, as long as you can exclude exports to the developed countries, there's no justification why you shouldn't have especially compulsory licensing. Maybe there isn't even a case to protect at all. Yesterday, somebody demonstrated that in developing countries, the percentage of expenditure on medicine is as high as in the developed world. But the total amount of money which is spent is very, very low. And simply by excluding protection of intellectual property, you wouldn't, in most cases, I think you wouldn't really exclude the incentives for innovation, but you could extend access of consumers in a very considerable way. What I have said so far is based on economic considerations, and basically it's based on efficiency considerations, but it's also a social approach. We have to look at how the efficiency gains are distributed between the right holders, the producers, and the consumers. And we can also apply competition law approach to this in view of this particular policy consideration. Thank you very much.
Well, let me also start by thanking Keith and Jerry for inviting me to this conference. It's a great, great pleasure to be here. I should maybe start by saying that my background is in economics, and I'm certainly not a competition policy or a competition law expert, and most of the work I have done on intellectual property is more on pharmaceutical pricing and also on sort of the aspects of intellectual property protection, foreign investment, and international trade flows. In the few minutes I have today, I would like to sort of comment on two different questions. First is to sort of ask what, from an economic perspective, would be like competition law to contribute in relation to intellectual property rights? And secondly, is there any role in this regard for the World Trade Organization? I'm obviously going to be cherry-picking in this regard, and in particular, I want to stress two ideas that are out there, well, in practice and in the literature, and that haven't been mentioned by the panelists. So let me start with a question first. What is the economic role of competition law in relation to intellectual property? The most ambitious view in that regard is probably the view that is expressed by the title of that session, and that is the idea that competition law should contain excessive protection of intellectual property. And the idea behind this view is that because of the TRIPS agreement, you now have a set of intellectual property standards that may be inappropriate for the needs of developing countries. Now, the 3 papers that were submitted to this session confirmed my prior views, and I think there is sort of virtual consensus here that competition law is unlikely to shift the balance implied by intellectual property policies in a major way towards improved competitive access to public goods. The excellent paper by Professor Fox offers a perspective on European competition law and US antitrust law, and suggests that in these jurisdictions, competition law has not been successful to limit excessive exploitation of intellectual property rights, despite the ray of light he pointed to. The paper by Professor Janis, among other things, points to the institutional weaknesses of competition regimes in developing countries and argues for minimal standards as a first-stage approach to the introduction of competition laws in developing countries. And the paper by Professor Ullrich warns that competition law is increasingly regarded as subordinate to intellectual property policies, which may dilute its role of promoting competitive access to public goods. So all this suggests that major corrections of excessive intellectual property rights will probably need to rely on correcting intellectual property rights per se, and for developing countries in particular, to make all the use of the flexibilities that exist under the TRIPS agreement. Nonetheless, having said this, I feel there is an important, if somewhat humbler, role for competition law in relation to intellectual property. And that, I think, is to ensure better economic outcomes on what might be called ancillary intellectual property regulations that affect competitive conditions. And let me make one specific point here in relation to the exhaustion of intellectual property rights. Economic studies of parallel importation have generally shown that it is ambiguous whether a regime of national exhaustion is welfare enhancing or welfare reducing. Keith has done a lot of work on this. The desirability of restrictions on parallel trade depends on what causes parallel trade, whether it's sort of price discrimination or whether it's sort of free riding on promotional activity. And it also depends on who's sort of parallel importing and who's parallel exporting. This suggests to me that the right way to go is to have a case-by-case approach to the permissibility of parallel importation. And in principle, such a regime can be established by adopting a uniform rule of international exhaustion, but at the same time allowing rights holders to establish private territorial restraints and licensing agreements, and then scrutinizing those licensing agreements by competition law on economic welfare grounds. And this, in fact, as far as I understand it, is the way the exhaustion doctrine actually operates in Japan, and that seems to me a sensible role that competition law can play. Secondly, let me make a few remarks about, what role, if any, is there for the WTO on competition law matters. An obvious way to approach that question is to look at the current proposals for an agreement on trade and competition policy and ask whether it would be a useful complement to the TRIPS agreement. And I would argue that this is unlikely to be the case, as even the most ambitious European proposals are limited to rules on transparency, voluntary cooperation, non-discrimination, and also especially rules against hardcore cartels. And these rules are certainly not irrelevant to concerns about anti-competitive behavior arising from intellectual property ownership, but they do not seem to address the competition concerns that are most central to intellectual property rights, notably unilateral conduct and restraints in licensing agreements. Given that there is no economic consensus or no consensus among economists and lawyers, and also no political will, to include these areas in a competition policy agreement, it is unlikely that, as I said, a competition policy agreement will be a useful complement to the TRIPS agreement. And this is without even addressing the question, why do we need an agreement at the WTO if much of that can be implemented unilaterally, and whether developing countries are in a position to negotiate competition law at the WTO when they're really disenchanted with a lot of the rule making that has resulted from the Uruguay round and the implementation difficulties that followed. Let me close by making a less ambitious proposal that might provide some benefits to developing countries without necessarily negotiating a complex competition law agreement. What if there was an obligation for developed countries to take into account in the application of their own competition policies the harm done to foreign producers and consumers, and in addition give foreign producers and consumers legal standing in developed country courts? This is a proposal that has been made by various people in the area of cartels, and I wonder to what extent it can be applied to anti-competitive behavior arising from intellectual property rights abuses. The attractiveness of this proposal lies in the fact that many firms with significant market power and also with substantial intellectual property portfolios are headquartered in developed countries. And secondly, developing country constituents could make use of the competition law infrastructure that exists in major developed country jurisdictions. I realize, of course, there are many constraints to such a proposal, not least that intellectual property rights are territorial. But I think that is an interesting proposal, and I would sort of like to have the views and thoughts and comments of the lawyers and economists represented here. So let me close here.
Thanks for Jerry and Keith for inviting me. This has been very stimulating at lots of different levels. I see lots of connections, and I feel standing here that I don't want to just simply comment on these three great papers, but every paper that I've heard, because I see so many connections with the antitrust, competition policy, intellectual property overlap. Unlike Professor Drexl, I really don't have any conclusions to give you. I just have sort of a way of thinking, which I hope I can leave you with at the end of my 7 minutes. And I'm sort of framing my comments in terms of really kind of a hypothetical. In other words, supposing I was representing a developing country that wanted to establish an intellectual property system that also acknowledged competition policy, what would we do? How would we work within the constraints of TRIPS? How would we take the information we have from old Europe, old America, whatever we're thinking about, in terms of their experiments with intellectual property and antitrust law and competition policy, and design such a statute in a developing country? This is obviously far from hypothetical. It's hypothetical in this context because I only have a few minutes to speak. But as many of you know, the Indian government reenacted its competition law as of December of last year, basically scrapped their Monopoly and Restrictive Trade Practices Act that was enacted in 1969 and replaced it with a competition bill of 2001 with TRIPS in mind, of course, but also really thinking about what type of model to pursue in terms of thinking about its antitrust policy. And if I had more time, I'd like to talk about that act. I obviously don't have time, and I'm still in the process of sort of digesting it and understanding it. So I'm going to really kind of start off with this sort of hypothetical. How exactly would a country devise such a law, such an intellectual property system? And there are many things I appreciate about this. One of the things I really appreciate about this particular panel is that whoever designed the title of the panel used the word competition law, which I guess is a natural thing to use rather than antitrust. And it's important to recognize that really when you think about US-style antitrust law, you really are thinking about, in some ways, a fairly narrow set of instruments to deal with the regulation of competition. For example, I think that this is kind of an example used in other contexts. A lot of the regulation of abusive practices and patent licensing, for example, in the U.S., would occur under preemption doctrine. It made sense within preemption doctrine in the U.S. because you're talking about a contract, and federal law, such as patent law, preempts contract, and therefore you had sort of restrictions on sort of abusive contracting practices. Think about Berlotti and Lear versus Atkins and so forth, use preemption doctrine. I'm not speaking about whether they got the law right, but I just want to kind of emphasize the dynamic that exists in the US in terms of regulating some activity using patent law that might not exist in other countries. If we need to think about competition law more broadly and simply say that, well, just because it doesn't exist in US antitrust law, that doesn't mean that it's not part and parcel of competition law in some way, shape, and form. Now, the first conceptual thing that I want to leave people with is the kind of underlying model that we seem to be having when we're thinking about intellectual property and antitrust law, whether it's developed in the context of the TRIPS agreement or if you're trying to study particular institutions like the CAFC. And that's the approach which I say get the property rights wrong, which I sort of vehemently say very, very boldly, wrong approach. What do I mean by that? I'm not saying property rights are not important. I'm saying that there's a conception about the relationship between intellectual property law and competition law that decouples the decision about what types of property entitlements you have from the decision about how the market is going to be structured. So in other words, the reason why you have decisions like the CAFC that basically says, okay, we're not going to mess with that under antitrust law because we don't want to mess with the delicate balance that intellectual property law has created to solve the incentive problems that arise from positive externalities, the appropriation problem, and revelation. I don't think it's really possible to decouple that property rights entitlement issue from the way you structure the market. In fact, I'll make 2 points of this more specifically, but you really need to think about how intellectual property law and competition law work in tandem to create sort of a competitive environment, as opposed to simply say one just simply deals with property rights, the other one deals with sort of the regulation or conduct in some sort of a market environment. There are aspects of intellectual property that determine how that conduct is going to occur, and we need to recognize that. And I just want to develop that argument in 2 ways. And this is the idea that I'm thinking about, that we can't just think about sort of IP systems dealing with property rights and then competition law thinking about regulation of competition. We need to think about what the competitive baselines are from which we develop IP systems that also have some respect for competition law issues. And the 2 sort of theoretical points I want to make is, when you think about the positive externality issue that you're trying to resolve with intellectual property rights, you're basically trying to create or narrow the difference between the social returns from innovation and the private returns from innovation. The basic idea behind the appropriation problem and the revelation problem is if I innovate, I create something new, unless I somehow can kind of have a property right in that thing, I may not be able to appropriate the full sets of rents. And therefore, from a social standpoint, we may not have enough investment in innovation. Now, the problem, of course, is they're twofold. One is the problem of overshooting. In other words, how do we deal with the problem where if we just think about the intellectual property system as creating these property rights that allow me to appropriate, that we don't overshoot, and we reach a situation where actually private appropriation, the private rate of return, is greater than the social rate of return, unless we actively think about how that rate of return is going to be generated in some sort of a market setting. And therefore, we need to be very careful in terms of how we define the property rights in terms of understanding how they're going to play out in some sort of market setting. So there's that one point. The other point is how do we measure these things? I know there's some work by Mansfield early on trying to look at the marginal rate of return from innovation. But the problem is when you're talking about innovation, you're talking about a new market in many instances. And if you're trying to measure the rates of return from that new market, you're sort of in a chicken and egg problem in lots of instances in trying to do that. And this problem arises, of course, if you're trying to sort of separate out the property rights entitlement problem from the competition regulation problem. The other point, just very quickly, there's a whole host of literature on something called the Ghosh conjecture. It has gotten some attention in the legal literature, especially in antitrust, having to do with a famous case called International Shoe. But I want to point out that when you think about get the property rights correct, and then let's worry about regulation, we're really thinking about sort of a Ghosh theorem type world, going back to the problem of social cost. So in other words, we get the property rights correct, and then we can bargain, and even if we could somehow abstract the property rights decision from the market in which the bargaining occurs, you still get the problem with the Ghosh conjecture, an overlooked article in which Ghosh pointed out that, and there's lots of ways to state the point, but the way to kind of phrase it, hopefully in a brief moment I have here, is that if you do have this market exclusivity that's associated with a product that's long-lived, so it's not just immediately consumed. So think about the kind of products that you think about in intellectual property markets: seeds, artwork, CDs, music, and so forth. They're not so much immediately consumed, but they have some sort of a durability associated with it. The owner of that exclusive right would have the incentive to reduce the durability of that. So these are the examples that a number of people talking about, the agricultural sector and talking about the MCA types of regulation and so forth, sort of technological fences, is really an evidence of the Coase conjecture in action. And therefore, we just simply focus on the Coase theorem in terms of understanding property rights, and then let's regulate the market later. We're ignoring some of the economic insights from the Coase conjecture. So that's very briefly the kind of theoretical coherence that Professor Janis was seeking. I know there are a lot of holes in this, but maybe it's a ship we can sail on for at least the next 2 minutes, which is all I have for. Okay, so once we understand the theoretical structure, let's then think about this problem. What exactly are these competitive baselines? And there are 2 points I want to raise about this. And I probably won't get to the 2 examples at the end, so let me just emphasize the 2 points. One of the debates in US competition law is the question of, should we have bright line rules? Should we basically say this conduct, this type of activity is wrong and therefore it's per se illegal? Or should we have more context-based standards? And in some of the discussion today, I think specifically, I think it was Professor Ullrich's paper and talk, suggested, what should we have a preference for rules versus standards? And I guess one approach to take to that is, as he suggested, the WTO enforces or sort of imposes an intellectual property regime, but does not impose necessarily the balance of an unfair competition. So why not simply sort of undo the balance by having per se rules in whatever competition law a developing country might enact? I'm actually against per se rules, and I just kind of make 3 quick arguments of why I'm against per se rules. One is more against the argument in defense of per se rules that talks about sort of competence issues. I think there's arguments being made that maybe a lot of the institutional structure in developing countries aren't there to analyze the, and I got 2 minutes there. Okay, whatever. Okay. I'll be done soon, I promise. The question is whether you have the competence institutionally to deal with the sort of economic data that is necessary to be able to do sort of a full-blown rule of reason type analysis. Now, I think that competence argument is a little bit misleading. Now, it really depends on what type of developing country you're thinking about. If you're thinking about India, some of the top-notch economic analysis is coming out of India. And if you're thinking about a lot of developing countries that move from state planning to more market-based, a lot of economic models we deal with, the kind of analysis of economic data, were developed in state-planned, centrally planned economies. So the competence issue seems a little bit misleading in my mind. What seems to be more salient against the per se, an argument in favor of per se rules, is we look at it in the U.S., and if you look at the debate in the U.S. over per se rules, the debate has shifted all over time. It's even a question about whether we even have a per se rule. So, the black letter law seems to be, price fixing is per se illegal, but we never, the fine print is, well, you got to figure out what price fixing is. So it might be the sense that we don't even have per se rules in the U.S. And the debates in about per se rules are really ones about, who should regulate or determine competitive rules. Should it be the courts? Should it be the legislature? Or should it be a self-regulation within the market? And one concern I have about just sort of moving quickly to per se rules, has to do with, if you want to really stimulate technological diffusion in developing countries, you sort of have to have some room for joint ventures, which means you then have to go through the debate that we had in the U.S. and other countries in terms of, well, what types of collusive activities among competitors is okay? And that debate has moved us towards a rule of reason approach in various different ways, and I think that might be more conducive to sort of the technological diffusion and sharing issues. Now, the third reason is more of sort of a legal doctrinal reason, which I just thought of while Professor Ullrich was talking, so this may not be fully baked, but at which point, since it's not fully baked, I'll just say it and run away and end my talks, and then you can raise the comments. And that is, if you think about within the TRIPS structure, Article 8 and Article 40, specifically Article 8, but I think the arguments would also apply to Article 40. If, let's say, a developing country does adopt a per se rule, let's say that all the kind of things that we don't think about per se, become per se in that particular country, one of the challenges that would arise, of course, is this sort of a diminution of intellectual property rights, the kind of guarantees that are required under TRIPS, to which, of course, a developing country has to go to either Article 13 and Article 30. And in order to make use of the Article 13 or Article 30 defense, the WTO, at least as I'm thinking about the Article 110.5 case, really looks for particularized circumstances. In other words, you want to have some degree of detail to see why you want to have an exemption rather than have a general exemption. And that also seems to me, at least working within the TRIP structure, leads more to a rule of reason approach rather than a per se approach. I have no idea how much time I have left, but I assume I have 0. So I'll just leave the rest for discussion, and I have a handout that summarizes some of these things.
Thank you very much. I can see so many hands which went up. On the other hand, I'm wondering whether Jerry allows any discussion.
We're disastrously delayed. Take 5 minutes, and then we'll have to retake these up Sunday. The second session on Sunday morning. We will come back to each of these sessions and reopen all of the issues.
Yes.
But take a couple of.
Yes, I would ask all participants who want to ask questions, keep it short. I think Pamela.
There was one thing that none of you mentioned that I think actually is really important, and that has happened both in the United States and in the European Union. That's really important, and that is that antitrust and competition authorities can actually provide some advice to legislatures, for example, if they are developing intellectual property rules. So the EU software directive was informed very much by competition policy in terms of the interoperability provisions. In the United States, the FTC and the Justice Department had some role in raising some questions about database protection legislation. There also are amicus briefs that the antitrust authorities can submit in some cases where there's over-expansive interpretation of intellectual property rules. And it seems to me that's actually a place where they can act in a way that actually preserves the public goods parts of intellectual property, which is, in the long run, best interest of society.
Mm-hmm. I think that wasn't quite a question, but a very important remark.
It's okay.
A very short comment on a related story. Short comment is, I think you're making this way too hard and way too complex. The related story comes from a colleague of mine in the Philippines who complains to me about the high price of patented seeds in the Philippines. How farmers pay way too much for the seeds. And I'm a Chicago person. I said, well, why do they buy the patented seeds? They should just buy the cheaper off-patent seeds. She says they're not available. They go to the store. There is one company selling the seeds. They sell only patented seeds, and they expect to pay a high price. So I tell her, the problem isn't with patent law. It's with the fact there's no competition. This occurs. The seed seller is bribed by the seed company to sell only one brand of seed. Very frequently, also, you can only get a loan from either the governmental agency or the local bank, which has been bribed by the seed company. You can only get the loan if you buy the patented seed. If you want to buy the unpatented seed, you will not be given the loan from the local agency. The problems in the developing world are grotesque and blunt, and we need to look not at the fancy intricacies of late 20th century European and American antitrust law, but rather 1910 American antitrust law and the sort of grotesque busting of trusts that was going on back then, where there seems to be very little argument about whether these sorts of activities should be actionable or not. And they go on in places like the Philippines, where there is literally no competition law whatsoever, even of the grossest, bluntest, most easily achievable sort.
Yes? That's what the back, yes. Yes?
There is a competition case in South Africa right now involving patents on antiretroviral drugs that Glaxo and Boehringer sell. And one of the positions that's been taken in the case, the Commission's been asked to act on, is the fact that if there's an access gap, if there's a gap between the number of people that should have access to an important medicine and the people that do get it, that would be the empirical thing. That they should have like a per se rule that it should be illegal to refuse to license patents on a reasonable term. So they want to make the refusal to license the patents to their competitors illegal in the case where the consequence of the monopoly is that there's inadequate access to the product. And they're trying to do that to the competition authority for two reasons. One is because it's cheap. You don't have to be represented at a tribunal in a fairly expensive legal system in South Africa under loser pay systems, which you'd have to in a normal compulsory licensing procedure under their statute. And you can just ask the government to do an administrative process to pursue the complaint, which is why people have been bringing their complaints to the competition authority. And the other reason is that TRIPS allows you to export your product if the license is issued as a remedy for anti-competitive practice, and it doesn't in the other case. And the other area, issue that's been raised is in fixed dose combinations. That is to say, you can buy from Indians a combination of drugs in a single pill that you can't buy from the Americans or the Europeans because of the patent barriers. And so the only supplier of the product would be people that would have to get, basically, and the generic suppliers have all been denied patents from the patent owners. And so that's actually a real case that's going on in South Africa right now. It's quite important.
Mm-hmm. Thank you. Yes, please.
Excuse me. Just wanted to emphasize, I think what Pam may have been alluding to a little bit, although I'll make a controversial statement that I may not agree with, which I think that with respect to Professor Ghosh's point that we've sort of separated intellectual property from competition, and I think we may have in the United States, but I think that's an artifact of the fact that we've created the specialized appellate court for patents. It seems to me that in terms of thinking about how to design patent systems in other countries or to design a world patent system, we should be very wary of creating a specialized appellate court for patents, because I think in terms of competition, obviously that's a disaster. And the only reason that, other courts definitely think about the interaction between intellectual property and competition, but the Court of Appeals of the Federal Circuit does not. So that's a cautionary tale, it seems to me, and somewhat unusual to the United States.
One more. Eleanor wants to.
I think we should start with the last remarks of the speakers. Eleanor.
Okay, thank you. I wanted to respond to a couple of remarks. First, for Pam Samuelson, yes, advocacy, competition advocacy is terribly important. This is part of what Tim Uris is doing in trying to cut back the boundaries of the government privilege and protection. Secondly, and this relates also to the second speaker on the bribery and seed aspect, when fraud is used, as it was in this case that you gave us, that should discredit the patent. And this also goes together with what Tim Uris is advocating, that there can be, of course, nations have to have a law that does it, but they should have a law that you would sacrifice the patent if it's done, if you're getting exclusionary effects by bribery. And then Jamie Love makes these really, really important points about how do you serve the people who are in desperate need of drugs, and there are manufacturers that have the drugs but just won't sell them except at the monopoly price. And I know from talking with them, there's some very important issues about how to redefine competition law and what it does. And for example, this is just one small thing. There's a lot more to be said. U.S., we've been saying we have to serve consumer welfare, but we define consumer welfare in a way that consumers don't recognize always. It means aggregate consumer welfare according to the ability of people to pay. The less developed countries need the distribution, not the base on which ability of people to pay. So there's a way in which we ought to be working at redefining what is consumer needs. I wouldn't even call it consumer welfare because that now is a term with baggage. That's all.
No.
Let me just make a quick. All I have to say, I guess, is yes, 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 yes. I mean, I forget how many questions there were, but yeah. I mean, I think this question about to go back to Professor Samuelson's point, it's a question of institutional design. I mean, I think the question of per se rule versus rule is useful, but you need to recognize, there are agencies, there are courts, there are a lot of institutions that are involved, and those institutions have changed and have shaped antitrust law and competition policy. So yeah, I think that's absolutely true. As far as Paul's point, yeah, sure. Why 1910? Go back even earlier. Go back to some of the English common law. I mean, one of the points I didn't get to was there are lots of different baselines for antitrust law that we have in the U.S. I kind of think about the structuralist baseline that Eleanor talked about a little bit as not that helpful, but I really do like the populist baselines that we had in the late the basic idea that the antitrust law is sort of a Magna Carta. I think it's very useful to think about it, even though there are limits to that approach as well. and I forget some of the other points, Professor Rice's point. Yeah, I don't know if it's particular to U.S., but it certainly seems to be embedded in the TRIPS debate, too, about what, it seems almost as antitrust is sort of an afterthought in that particular context, so.
I just want to make one general comment. The whole point I was trying to make is that our way of looking at antitrust may be pointing in the wrong direction. The problem is that too many may follow. And it seems to me to be a little bit arrogant to suggest to developing countries what their competition laws should look like. We should rather give them the best we can give in antitrust terms from all these approaches. This seems to me to be the real important point. They must, and any tool which we have should pass to them and not go to a sort of a harmonization de facto by applying in the United States, in Europe, in Japan, always the same kind of antitrust approach. It was a major, and I'm speaking as a European, a major mistake for me as a European that the Europeans just simply followed the US, leaving all the bargaining position which they have had on an empty table. That was the wrong political approach. Thank you.
Just a last remark from my side. I very much like the example of the Philippines. It simply demonstrates how necessary it is to implement competition laws in developing countries, irrespective of the problem of IP. The example was one on vertical restraints, and not really linked to the issue of intellectual property. And when I read Hanns Ullrich's paper, the point really is we have to think what kind of competition law developing countries need, and that's not the kind of law Hanns Ullrich unfortunately had to demonstrate us today. I think it should be quite different. Last remark on the last intervention. I just want to give you the example of Peru. They established one administrative authority, which is competent both for intellectual property enforcement and competition law enforcement. And it seems, I have just read an expertise on this particular institution. It seems to work nicely. So maybe that might be an approach for developing countries to bring the two fields together. And hopefully you might have people there sitting there who have a very strong competition policy view of what is going on in their countries. That might help, but it might also develop in the wrong direction because such institutions might be captured by interest groups. I'm very cautious about it. Thank you very much.